us be ready, start. This appeal is directed against the judgment and final order dated 7th October 2002 passed by the Division Bench of the High Court of Gujarat, whereby the High Court set aside the judgment and decree dated 14th December 1982 passed by the civil judge Jamnagar, directing the state government to pay a sum of rupees 2 lakhs with costs and interest, and dismissed the civil suit as well as cross objections filed by the appellant firm for recovery of the aggregate amount of rupees 3 lakhs on account of different counts as specified in the claim of the said suit. The brief facts of the case are as follows. The appellant firm, a partnership firm registered under the Indian Partnership Act, is carrying on the business of construction of roads, buildings, dams, etc., mostly in Saurashtra and also in other parts of the state of Gujarat. In response to the invitation of tender by the state government for construction of dam in Jamnagar district, the appellant firm quoted and offered to construct the same for the quotation, specifications and design of the dam wide covering letter dated 5 June 1970. In the said letter, the appellant firm also offered that they would give rebate of 4% provided the final bill be paid within 3 months from the date of completion of the work. The offer of the appellant being the lowest amongst other parties, it was accepted by the state government with the clause that the construction work was to be completed within a period of 24 months from the works order dated 7th September 1970, which was subsequently clarified that the period of 24 months was to be commenced from the date of commencement of work. During the execution of the said work, the executive engineer who was in charge of the project made certain additions, alterations and variations in respect of certain items of work and directed the appellant to carry out additional and alteration work as specified in the writing form time to time. The final decision as to the alteration in respect of certain items of work and particularly in respect of the depth of foundation, which is known as cut-off trenches, took long time, with the result that the firm was required to attend the larger quantity of work and thus entitled for extra payment for the additional work. As per the works contract, the firm was not paid the running bill within the specified time and therefore suffered loss. On 16th September 1976, the firm lodged a consolidated statement of their claims for the additional or altered works etc. to the executive engineer. As there was no response, the firm served a statutory notice. The appeal was filed therefrom to the Kerala Sales Tax Appellate Tribunal, which after going through the records referred to the provisions of refund as contained in section 44 of the KGST Act, which reads as follows: refunds when an assessing authority finds at the time of final assessment that the dealer has paid tax in excess of what is due from him. Stop.